As per the 1995 Constitution, Article 129(1)(d) compels the state to put in place Qadhi courts with the purpose to address marriage, divorce, inheritance of property, guardianship, and to protect the rights of Muslim women and girls. Although the Constitution provides the enactment of Qadhi courts in the country, nothing much has been done to formalize these courts. It's against this background that a group of women Muslim lawyers have filed a petition against the Attorney General demanding for the operationalization of Qadhi courts in the country.
We are from an NGO called the Islamic Women Lawyers Initiative for Justice and Peace, and we have filed a constitutional petition on behalf of the women in Uganda, especially the Muslim women. We are petitioning for operationalization and formalization of Qadhi's courts in Uganda. The Qadhi's courts are the Islamic adjudication courts that are set up by the Muslims to adjudicate over Muslim personal laws. These courts are provided for under Article 129 of the Constitution, and they are placed under the justice system of Uganda. Issues and divorce issues, they force them to go and bring their husbands. And this is not right, because if I have come to report my husband and he has done injustice to me, how am I going to summon him? So they don't have that summoning procedure that the court will send a clerk to go to the husband and drag them to court. And we feel like all those are injustices that ought to be addressed. And the consequences of the informality of these courts is that women have decided to run away from the courts. They are choosing to just handle their things, to take the matters, the Muslim personal law matters, in their hands. When we talk of Muslim personal law, we mean matters of marriage, divorce, inheritance, maintenance of children, and all that. The execution bit is hard. You get a ruling in your favor and you cannot execute it because they are not formalized. And we have our counterparts in Kenya. They are already operating under the Qadhi's courts. It is very formal. They are at the level of magistrates' courts. They are under the government. They are under the state. Their employees are under the state. It is properly managed. They have regulations. They have procedure, and everything is good. Why can't we borrow from them? Why can't we borrow a leaf from them and bring it back home and see that these courts are operationalized, to see that women's affairs are handled?
The petitioners hold the view that some women have made use of these Qadhi courts, though their decisions are left not binding, as the rights of women continue to be violated.
Also, the decisions in these Qadhi's courts are not binding. They are not binding. Most probably, in most cases, we see that the people who go there and they get their judgments in their favor, they are appealed against in this court in the high courts and all that. And usually the ground is that the Qadhi's courts did not have jurisdiction to handle. And we know that is because they are not formally operationalized. If we have a law, an act of parliament enacting their operationalization, and they are streamlined and they are properly placed under this justice system of Uganda, we know that there will be justice, and all that will be solved.
A private member's bill was presented to Parliament in 2022, seeking to operationalize these courts, but nothing to date has been done, with no efforts by Parliament to operationalize Article 129.
It's a unique law, and it pertains the Islamic rulings. And these courts that we have here, the judges and the lawyers, they don't know about the Muslim personal law. We have different grounds of divorce. We have, for example, in custody, we have different rulings as to which parent should take custody of the child and all that. So we believe that these matters, succession rules are also different. We believe that these matters, being religious and spiritual matters, they deserve to be handled by people who are most suited, who have the knowledge in Muslim personal law. And that one is lacking in these in the ordinary courts that we have. That is why the framers of the Constitution, I think they were alive to that fact. That is why they provided for the Qadhi's courts in their system, because they knew that Muslim personal law is a kind of unique law that cannot just be handled in our ordinary courts. That is why in our petition we do seek that these courts go we do seek that these courts are properly placed in the justice system of Uganda, so that even those matters can properly be addressed and they have the formality that they deserve.
They also challenged the gender imbalances of the panel presiding over these Qadhi courts.
We are not afraid, because we know that Muslims believe that this is a spiritual calling. We all believe that if we are best judged by our Islamic principles, the Quran, the traditions of our Prophet, we know that we are undergoing a spiritual calling. So we don't expect that there will be chaos, because Muslims have always pledged to do that. Muslims have always cried to see that we have that the Qadhi's courts formally operating, properly aligned, well regulated. That is the only thing that is missing in our courts. Otherwise, they would be very glad. We have talked to a team of women. They always complain to our NGO, and we promise that we shall raise the voices. We are not against the operationalization or the operation of Qadhi's courts. We just want them to be streamlined. We want them to be formal. We want the decisions that come from the Qadhi's courts to be recognized in these courts, not to be appealed against on ground of lack of jurisdiction. And yet even the Constitution of Uganda itself is in support, and it provides for them. That is all that we are fighting for. We just want order there. We just want the women to get justice, the justice that they deserve in those courts. We want to have a feel of their existence. That is what we wish for. Of the Qadhi's courts, we do not mean them being judges, but there is always a panel, adjudication. We wish to have female representatives on the panel to best handle the matters that are sensitive to women, matters they cannot properly explain to the men. If we have male adjudicators on the panel that they can trust, even the Quran itself and the Sharia talks about having 2 female representatives in place of 1 man. So it is totally not against the rules of Islam to have a female representative in the adjudication panel of matters of Muslim personal law.
The case was filed by Mwanga Mastula Asha and women lawyers under Islamic Women's Initiatives for Justice, Law and Peace.
Wenn es go aí, vai dar. Durante a hora, vai ter que ir. Vamos lá,